civil matters and across the board, Manoj.
Yes. Asian resurfacing.
Yes, Asian. I need not place those judgments for the Asian resurfacing Manoj, because in the interim order, your lordships have elaborated about the contents. And from the reading of the first judgment itself, it appears, Manoj, that that was a case where the only question was whether against an interlocutory order, an appeal could be filed, a revision could be filed, or Article 226, 227 could be entertained. So it's
in the context of PC Act.
In the PC.
There was no issue of any civil proceedings arising in that. There was no issue equally, my lords, what should be done with the interim orders. Of course, it appears that in the course of arguments, the aspect of delay, my lords, which nobody can deny, my lord, that proceedings are getting delayed in the high courts, especially in some high courts, my lord, like the Allahabad High Court and Patna High Court and so on. And the
Probably
delays
the
are...
judges also were, that was what was weighing with them, that otherwise, stays just continue for decades to an end, particularly in the larger high courts.
And sometimes the delays are on account of the fact that the accused person will get an interim order and that continues. So they take advantage of it. The trials get frustrated, witnesses, long time lapse, the memories of the witnesses may fade. And in some cases, the respondents, the state is the culprit, they don't file affidavits promptly. And sometimes also, especially in the courts which I've mentioned, it is systemic fault. So,
The judges, yes, in
fault itself could be for more than one reason, because there are 160 vacant posts in the High Court of Allahabad and only 90 judges.
His filing is enormous.
Filing is enormous. Matters don't get listed sometimes, and sometimes when they're listed, the judges are overloaded with work.
And this is
150 cases.
Allahabad, the problem is magnified.
Yes.
But the same issue, brother, just focusing in Karnataka, I know that same issue in the larger high courts like Mumbai, and not the fault of judges, or for that matter, the litigant, because if there are 200 matters on board every day, 150 matters, 200 matters, and you have to write some reasons, give some, order which shows deliberation, application of mind. Impossible for the entire board to be completed.
And Allahabad is compounded by the strikes. The lawyers, I have the secretary, Nitin Sharma is here, who is instrumental in filing. In fact, my lord, a very sad episode happened, and this goes back a long time, my lord. Justice Mishra and Justice Mittal is aware, Lord. The VC Mishra,
Oh, yes,
8 days, Lord.
absolutely.
So for months together, the strikes used to go on and at a drop of hat.
No longer, actually. I don't think after 2000 and.
Chief Justice Sodhi, Lord, was the person who, despite so many judgments, because I don't know why the lawyers adopt this trade unionism tool.
5 days.
10,000 meters.
So it's not that once a while it happens quite frequently and regularly.
Maybe what is to be done then? What is the solution? Because if a judge grants a stay in a 482, they virtually means that nothing is going to come up in the next.
Look, the
maybe
first
for-
question which perhaps the lawyer will have to look into is, do we find a solution, Lord, which is creates
Worse
a
than.
greater problem, which is worse than the disease?
Because it results in one more round again.
No, we have to create in every discipline civil revisions, appeals, and tax, and a separate bench which will consider now the extension of same amount of time and the court says in resurfacing, give reasons while extending, which really means not that both sides have to be heard. It's not like that we not able to take up, then we say extend it till the next day automatically. So, and that can happen in any court, not even in this court, it can happen. The matters for some reason, some important matter is going on, other matters are not taken up. Your Lordship normally asks not any extension required, it's extended in the normal course. So the judges are not to be blamed, they are making the best efforts, not in the difficult circumstances.
Granted interim relief after it was argued prima facie, you see.
Yes.
So when it comes up for extension, even if it's another bench, it's a principle of judicial respect for the fact that even assuming the stay was granted by another bench, it has applied its mind.
Yes. So the question, that's one important question, or do we come out with some formula, etc., which in this manner results in a vacation of a stay order with application of mind. And what is this formula? Is automatic. Neither the Supreme Court is applying its mind, because this is a kind of a judicial legislation. Automatic vacate for all cases, for all times. So because of this, this court is not applying its mind to the facts of this case, that particular case, and High Court is also not applying. And the second resurfacing which followed, this court directs the magistrates that you have to implement this, proceed.
But in some states, there are contempt petitions filed against the honorable judges. Because of the direction that it is the responsibility of the concerned learned judge to proceed. Some litigants, in Punjab, Haryana, in 3 or 4 states, contempt petitions are filed joining the honorable judges by me, the judges who were to conduct trial. So I joined my learned friend, the solution perhaps is more severe than the disease. So we need to find out a solution, but this definitely is not the solution.
So I submit that this automatic reservation is no solution, neither practically nor on a legal plane.
What do you have to say about Article 226(3)?
Now, that's what the first question is, that Article 226 is a basic feature of the Constitution. If 226(3) is to be applied, then it will have to be tested whether that can be done. If Article 226 is part of the basic structure which this court has repeatedly held, it is. So it cannot be taken away, it cannot be whittled down. Neither by constitutional amendment, this is something like Indira Gandhi's case, where now by constitutional amendment, you are deciding that it will get automatically vacated. So who is applying the mind? It's interference with the process of judicial review. So if challenged, it will be liable to be struck down. But the High Courts, in some cases which we have cited, have therefore said that this is direct. They took another route. In Bombay High Court has also taken that view.
Yeah. And
Madras High Court
this provision came in by the 44th Amendment.
Yes. So I think that's the best solution, to leave it as directory, my lord. Otherwise, my lord, we will have to amend the petition and question 226(3) as ultra virus. 368 cannot be used to bring in a provision of this nature. But in a way, my lord, the direction in Asia resurfacing goes much beyond Article 226(3). 226(3) says that upon the making of an application by the other side to vacate, if then it is not decided in 15 days. Here it is not required. The other side has to just sleep over for 6 months to get vacated.
So technically, even if it's ex parte, after 6 months, the state would be vacated.
Vacated. In many cases, it has happened. That's why in the second case, this court went ahead logically to direct the magistrates, to proceed, implement.
The judgments are there for lordship, my lord. Perhaps, my lord, this may also be, my lord, necessary for lordships to consider in this, my lord, with the constitution bench, whether 226(3) is mandatory or directory, because there are diverse opinions among the various high courts, my lord. All those judgments are also there before lordship by way of a compilation filed by me. I'll place them.
That will result in widening of the
That's
scope, my
not the
lord.
question.
Maybe, but that will be a relevant thing also.
Well, possibly that's not the question, my lord, right now, 226(3).
Then we'll have to come with a petition questioning the validity of 226(3).
No, that's an interpretation of 226(3).
No, mere interpretation. Then we'll like to challenge the validity of.
Why should we go in?
But if it is to be interpreted, then it is directory.
Yes. And the high courts have given good reasons, my lord. Two high courts have given good reasons.
Yeah, but हमेशा solution लाता है, problem create करता है. Sorry.
Vision before the amendment, that is in the footnote to this SCC EBC copy. If you have the red book with you, you have this red one. The earlier provision is in the footnote. This is very good. It gives all the footnotes. Mr. Dwivedi can read it from this book. It's at page 186. The earlier provision said that if you have not.
Petition
Yeah,
for the
just read it.
redress of any injury referred to in subclause B or C of clause 1 shall be entertained if any other remedy for such redress, that's alternate remedy. Or under law for time being in force.
4 and 5. Now see 4 and 5. 4 and 5.
No interim order shall, whether by way of injunction or stay or in any other manner, shall be made on in any proceedings relating to a petition under clause 1 unless copies of such petition and of all documents in support of plea for such interim order are furnished to the party against whom such petition is filed or proposed to be filed. Opportunity is given such party to be heard in the, that's fine, my lord.
Now see how 5 was. 5 was very carefully framed.
The High Court may dispense with the requirements of subclauses A, B, or
And
of
make.
clause,
And
of
make
clause
an interim.
4 and make an interim order in writing that it is necessary so to do for preventing any loss being caused to the petitioner, which cannot be adequately compensated in money, but any such interim order shall, if it is not vacated earlier, cease to have effect on the expiry of the period of 14 days from the date on which it is made, unless the said requirements have been complied with before the expiry of that period and High Court has continued the operation of the interim order. So that's.
This will not pose any problem.
Yeah.
The amendment, if your lordship sees, which is now there,
See, this amendment will apply only when interest is granted without
Without
furnishing copy
furnishing
and without hearing.
without it.
So therefore, if there is a notice issued or in some high court practices to serve state in advance,
Yes,
this will not apply at all.
this will not.
If copy is given and notice is served,
Served.
then this will not apply.
Yes.
Hardly significant.
We can
We don't need to go into it. Going to 226(3), Lord, in this matter. It operates in a different way on
And
different.
in a very limited
conditions.
cases, it will apply.
Yes.
because once A and B is complied with, then there is no question of an automatic
In high
vacation.
courts, in both
Then,
high courts,
I'll tell you, Lord, I would submit before your lordships why it's not necessary. Asia resurfacing essentially concentrates on stay of trials. Stay of trials would arise either in 482 or other jurisdictions.
227.
227, not in 226.
26.
But 226, my lord, we would be taking support, my lord, to substantiate other submissions. Just to say, my lord, that first, it's a part of the constitution. Here, it's a judicial continuing mandamus. Second, there is at least a requirement of an aggrieved party applied for vacating the stay. Here,
Automatic, without.
person who is not vigilant enough and sits for 6 months, he is put to premium by getting the stay against him vacated. He has to do nothing except being negligent, to put it, my lord, a little harsh. So that's the position. So 226 may perhaps not, my lord, require your lordship's attention in this matter.
Lord, the copies are served in advance on the state councils,
Absolutely.
except in private disputes. Otherwise, their state councils are always served. And they have an opportunity of being heard. It's other matter that the state government advocates may not be having instructions, etc. So they get time alerts.
Thing in particular that you would like to add,
Only 2 or 3 things.
No, I have not stated.
all right, we'll hear you. All right. So,
I'll not take more.
how would you like to formulate the submission then, Mr. Dwivedi?
Lord, I have 7 points. Lord.
7 points, all right.
Yes.
Just tell us. 1 second.
The judgments I have mentioned in my written submission, Lord, I will not be
Correct.
taking your lordship through it. The propositions are all well settled and well known to your lords. Lordships. First is that this direction
Which is
amounts
the
to
vol-
judi-
Which is that volume, Mr. Dwivedi, your written submissions?
Separate volume.
By the names.
So,
Mr. Rakesh.
Separate folder, there's a.
Separate volume.
it's a separate volume. High Court bar.
yes.
They were allowed to intervene in the High Court. And
Correct.
the first submission is that this direction of automatic vacation is laying down of a general norm,
Direction for,
automatic vacation of interim order lays down a general norm, and therefore it is in the nature of judicial legislation. And this court, Lord, does not engage in judicial legislation.
yes,
In the same sex matter, my lord, the lordships have elaborated. I don't need to, my lords. The second submission, my lord, that Article 226 is a part of the basic structure of the Constitution. And it can neither be shut out or nor whittled. Nor whittled down. Either by constitutional amendment or by legislation and ought not to be shut out or whittled down in exercise of powers under Article 141 and 142. This is also because, my lord, the High Court,
this is the third point or the second?
third point,
Third point,
is part of the same point, my lord.
all right,
This is because the High Court enjoys a high constitutional status and it's not subordinate, my lord, to the Supreme Court. This also, my lord, has been held in several judgments. So merely because, you know, there is a problem arising, that doesn't mean that the power of the High Court should be curtailed. And there should be any kind of a general direction that even if you have not applied, even if you have not vacated, we are saying it will stand vacated. And even we will not apply our mind, it will get automatically vacated.
yes,
So the third point, therefore, is that the automatic vacation is neither hinged on application of mind by the High Court nor by the Supreme Court. And application of mind is the essence of judicial decision making. Without which the decision would be arbitrary. So even though not Article 14, etc., fundamental rights are not available to test the judicial dictums, yet your lordships have consistently observed that arbitrariness in decision making is to be avoided. The fourth point is the arbitrariness and the discriminatory character of this direction arises from the fact that it lumps together all sorts of cases, civil, criminal, tax, irrespective of facticity,
Irrespective.
of the cases, nature of jurisdiction, and determination of fault. For if I am delaying, Lord, I having obtained interim order twice, thrice, four, I can understand High Court vacates it. Not by an automatic direction, but High Court vacates it because then the next is, Lord, a speedy trial includes early termination of vexatious trial also. And this direction does not reasonably balance the two aspects. So both section 482 and 226 are available for quashing of FIRs and charge sheets and so even charges in an appropriate case. So one can understand that the court may be directed to be slow, lords, or to give reasons or to hear. So these are 3-4 directions which can be and should be rather introduced so that straight away, or maybe it can also be said that in heinous crimes and serious financial irregularities cases or economic offenses, if an interim order is to be given, it should be initially for a short period, as the lordship says, till the next date of listing, so that an opportunity, effective opportunity is there. Government council may not be having instructions, so and that will not prevent the High Court from granting appropriate relief. The relief can vary. Sometimes it can be arrest, sometimes it can be staying the whole proceedings. It all depends upon the circumstances. Because we have also seen that there are cases where the matters have been settled up to the Supreme Court and people still will not fight it out by filing FIRs, then they resort to criminal proceedings. Some civil nature disputes, they're all carried only to harass. So if in such cases a direction is given till further orders, all that power is there under 226. So there has to be a proper balancing and some minimal directions alone should be given so that there is a guidance to the court, High Court. And lastly, this ignores two precedents, though in the context of trial, not interim order, that is Amtule's case and P. Ramchandra Rao. At page 4 of my written submission, in paragraph 4, I have given the paragraphs at the footnote. I will stress only para 82, 83, 86, 93 and 94 of Antule's case, that is 1992 1 SCC 225,
In your submissions, where is it, you said?
paragraph 4. I very briefly stated. Two constitution benches in A.R. Antule's case and P. Ramchandra Rao have, while dealing with the fundamental right to speedy trial under Article 21, held that it is not permissible for this court to fix time limits for completion of trials. The reason assigned is that delay in trial could happen for a variety of reasons. May I read these two judgments or Lord, I can leave?
No, it's very well settled.
P. Ramchandra Rao, my lords, may be seen only because
Okay.
after Antule's case came 3 judgments of this court, where this court identically as in Asia resurfacing proceeded to say that if trial is not completed in 360 days, then trial will terminate. So the matter went back to P. Ramchandra Rao, and they said that this is judicial legislation.
It's in your convenience compilation?
Yes, yes, it is there. Correct.
1399.
PDF 1399. Laws will find the reference, the issue which was involved. And towards the middle, you'll also find Rajdev Sharma 1, 2. All these cases, they said, if not concluded, it will terminate. Then in paragraph 19, Antule's case is noted. And placitum F, if the lordship comes to placitum F. There are other factors contributing to the delay at the trial. And so all these various reasons for delays are noted, and the court says it's all relative. First is non-availability of the counsel, non-availability of accused, interlocutory proceedings, other systemic delays. In addition, court noted that in certain cases, there may be a large number of witnesses. In some offenses, by their very nature, the evidence may be lengthy. In Kartar Singh, another constitution bench opined that delay is dependent on the circumstances of each case because reasons for delay will vary, such as one, delay in investigation on account of the widespread ramifications of the crime and is designed network either nationally or internationally, the deliberate absence of witness or witnesses, crowded dockets on the file of the court, etc. So all that is said, and then paragraph 20. Several cases coming to our notice while hearing appeals, petitions, and miscellaneous petitions, such as for bail and quashing of proceedings, reveal, apart from inadequate judge strength, other factors contributing to the delay at trial. Generally speaking, these are absence of or delay in upon. Again, those reasons are mentioned. And then 21, the question is posed, is it at all necessary to have limitation, bars terminating trials and proceedings? Is there no effective mechanism available for achieving the same end? The Criminal Procedure Code as it stands incorporates a few provisions to which resort can be had for protecting the interest of accused and saving him from unreasonable prolixity or laxity at the trial amounting to oppression. Section 309 is then referred to. Your Lordships can then leave the rest. Please come to 22. Legislation is that source of law which consists in the declaration of legal rules. Again, this definition of, and then the court holds.
Subject of bail.
Last line, at page 1421. Bars of limitation judicially engrafted are no doubt meant to provide a solution to the aforementioned problems, but a solution of this nature gives rise to greater problems like scuttling. A trial without adjudication, stultifying access to justice and giving easy exit from the solution, from the portals of justice. Such general remedial measures cannot be said to be apt solutions. For two reasons, we hold that such bars of limitations are uncalled for, impermissible. First, because it tantamounts to impermissible legislation, an activity beyond the power of the Constitution conferred on the judiciary. And secondly, because such bars of limitation fly in the face of law laid down by the Constitution bench in A.R. Amtule's case, therefore run counter to the doctrine of precedence. There's a quote from William Wade's Judicial Activism and so on. I can leave it. And then 27, describing periods of limitation at the end of which the trial court would be obliged to terminate the proceedings and necessarily grant acquit or discharge the accused, and further, making such directions applicable to all the cases in the present and for the future amounts to legislation which in our opinion cannot be done by judicial directives and within the arena of judicial lawmaking power available to the constitutional courts. Howsoever liberally we may interpret Article 32, 21, 141, 142 of the Constitution. The dividing line is but perceptible. Courts can declare the law, they can interpret the law, they can remove obvious lacunae and fill the gaps, but they cannot entrench upon the field of legislation properly meant for the legislature. Binding directions can be issued. For enforcing the law, and appropriate directions may issue, including laying down of time limits or chalking out a calendar for proceeding to redeem the injustice done or for taking care of rights violated in a case, in a given case, or set of cases depending on facts brought to the notice of the court. This is permissible for the judiciary to do so, but it may not, like the legislature, enact a provision akin to or on the lines of Chapter 36 of the Code of Criminal Procedure 1973. The other reason why the bars of limitation enacted in Common Cause 2, Rajdev Sharma 1, Rajdev Sharma 2 cannot be sustained is that these decisions, though 2 or 3 judge decisions, run counter to the extent to the dictum of the Constitution bench in Antule's case. Therefore, cannot be said to be good law to the extent they are in breach of the doctrine of precedence. The well-settled principle of precedence which are crystallized into a rule of law. Now that's known, Mullahs. And then they affirmed the directions in para 29. So Mullah, it's somewhat similar. These kind of directions are actually judicial legislations, something which even Article 368 will not include within its fold.
Yes.
And there is, Mullah, apart from these submissions, what happens is in the course of it, Mullah, that by issuing these directions, we are not enabling the high courts, Mullah, to conduct themselves appropriately, Mullah, in dealing with the case, but rather disabling them and downgrading the status. But over the course of years, and in one such matter, Lord, in this court itself, when Chief Justice Keher was, I think Vijay was there, was retiring, Lord, there was some letter, Lord, from the law minister.
Right.
Yes.
And regarding selections of judicial officers in the high courts and the rules to be made. And then the committee of judges, Lord, of this court, Lord, that accepted that proposition favorably, and immediately, Lord, a suo motu petition was listed. And Justice Goel was chairman of the committee also, and he sat in the bench also, Lord, immediately. And this was just a few days before the Chief Justice was retiring. So the matter went on for 2 days, and there were so many judgments. I said, how can you intervene? How can you take over the power of the High Court? It was a very serious matter. And ultimately, it's the second case where the bench was disbanded after that Keshwanand.
Yes.
It's on the.
So just after the lunch, then he inquired, do you really think this requires serious consideration and we must? I said, don't be hasty in this matter. For so many years, this has been continuing. Even if you want to change, please consider it carefully and then come out. So there is some kind of a tendency sometimes that we try to limit the powers of the high courts. What we really need is not that the high courts should be getting on with their functions and discharging their duties and functions and powers under the constitution more effectively. I don't need to elaborate. Lord, your lordships are all more aware than me about what is happening in various high courts. So, but then these are not the solutions at all. Let's not curb the high court. The time is to rebuild the high court and put them on a strong footing so that the high courts function like high court. Because they are ultimately, there is some kind of course, there's no such federalism in the judicial field as we have in the other. Where the judiciary is structured differently. It has some various elements of unitary operations. But at the same time, the High Court is the ultimate court in the state. 80 or 90% of the litigants are not able to come to the Supreme Court. Now, therefore, we don't need to not keep on. Different methods have to be found. Able judges, less strikes, more lawyers, because we don't have hearing. I wonder what will happen after some time if the high courts are not having final hearing. We used to sit. When I was in law first day, I used to come and I heard the whole of Keshwanand Bharti just and I used to sit with a register behind. So by hearing, even in high courts, we have learned from the seniors how they are arguing, how they're responding. But today, what we are finding is less of arguments and interim orders. People don't understand what happened in one case, what happened, why not in the other case, in this case. So it's ultimately that part somehow in some way has to be tackled. Unless the high courts are put on rails as constitutionally imagined by the framers of the constitution, there will be dark days for this court. Ultimately, high courts are the feeding source for this court, main feeding source. So let's put high court on the rails, strengthen them. That's the only solution, not this kind of tickling that after somebody suggests that after 3 adjournments it should be automatically vacated. I mean, so we are distrusting the high court judges. All these propositions show that we don't have trust on the high court judges. Somehow we feel something wrong is happening there. Maybe.
There was a similar provision actually in the Central Excise Act, or Mrs. Array, the tax, which was then dealt with by several high courts, that there can't be an automatic vacation of stay merely because the court is not able to apply its mind.
At page 5, you'll also
That
find
was read down, my lord, by this court.
At page 5, Pepsi.
Pepsi.
That's right, Pepsi. That's it. 2021.
And surprising, I'm surprised that Justice Nariman went down that line and accepted the proposition. He believes in basic structure. But and in this second case, in paragraph 6 of my written submission, or Pepsi mein hai, no. In Pepsi, Justice Nariman himself said that diluted it, struck down portions of it, and said that only if there is fault of the applicant, then it will stand automatically vacated, not otherwise. So he adopted the fault principle.
So there are two problems. One, the automatic vacation of stay prejudices a litigant, irrespective of the conduct of that litigant, because there are circumstances of which the litigant has no control. And yet, there are many times systemic flaws.
Yes.
As a result of which, irrespective of what the litigant has in terms of infrastructure available to him or her, stays are vacated by this logic.
Yes.
And second, the vacating of an order of stay is also a judicial act. The vacating of an order of stay is not an administrative act. So by directing that the stay will stand vacated without application of mind, a judicial order is in force, as a result of which Notwithstanding the fact that the earlier bench had applied its mind, given reasons
Yes.
for the interim order,
That's right.
applied its, there's judicial application of mind to what the prima facie merits of the case were. Subsequently, the stay is vacated without any application of
And
mind.
nobody, not even this.
Normally, when we vacate an order of stay, you give reasons for vacating an order of stay. Maybe that the litigant had abused his, abused that process, or he had concealed facts from the court.
And every day we are having appeals here against interim bails
Yes.
granted, and interim orders also people are coming.
Actually, it amounts to withdrawing High Court's jurisdiction.
Absolutely.
Judicially taken away. 226, 482,
actually,
227.
Great distrust in the High Court, which is reflect. That's why I was compelled to make those submissions, with great deference. It's actually indicating distrust in the High Court judges. So why are we having the High Court at all?
In fact, that's why many of us don't lay down outer time limits for the high courts to decide cases. In fact,
Lordship say guardedly endeavor to do so and like that. And even when it is said, Lord, in clear terms, yet Lordship considers it to be directory. It's not that a judgment will be set aside merely because it has transgressed 365 days and comes after 367 days. That's why I was compelled. These solutions, let's not find solutions. Let the High Court have that full wide jurisdiction which your Lordships have said under 226. Ultimately, even this court will get clogged. If there are 4 benches extending orders every time, then there will be so many more SLPs coming here, then your Lordships' precious time will be involved in dealing with them.
So the High Courts are ignoring this.
Power to grant interim order is, that's the last one, the power to grant interim order is inherent in Article 226, 227 and 482. It doesn't stand outside it. That is only to preserve
should also be available.
and protect. That's all of them. 285, the High Court has dealt with this aspect of interim orders. The Lordship may just note 285 to 287. They have noted. PDF 311.
in the same compilation or
Yeah.
convenience compilation
Main paper.
or the paper book.
Main paper.
And I must commend, Lord, the judgment is very exhaustive, though it's a little bit lengthy, Lord, but it deals with a High Court dealing with a Supreme Court judgment, Lord, has to be careful with all due care and a very well written judgment. Lord. तो ठीक है, क्या करूं उसको? 13 of my written note was at page 7 in Fazalullah Khan versus Akbar contractor. The question was whether this direction will apply to interim orders granted by Supreme Court itself. It said no, it will not apply to 32. So 32, 226, ultimately both are very important constitutional powers. That observation is per incurium because there was no such issue involved
It
in
was
that.
not an issue before the bench at
Yeah.
all.
So following what your Lordship said in Article 370 case about P. Premnath Kaur's judgment. Grateful.
I'll not take more than 5-7 minutes, Mullah.
Yes.
I filed an intervention application.
If you don't mind, can I complete?
Yeah.
Can I complete? You might take
Can
a-
we complete this side? I'll just take five
There's no
minutes.
side.
No, there is no side.
Really.
There is no side.
So we'll
Yes.
let the solicitor complete, then we'll hear you for 5 minutes. Sure.
Well, just, Lord, I'll summarize, my Lord. Lord, I have, for your Lordship's convenience, my Lord, I have made certain bullet points which are, my lord, mailed today in the morning. And I'm not going to read any of them, my lord. First, at the outset, I may say, my lord, my first respectful submission is that by a judicial mandamus or a continuing mandamus, the judicial discretion of the High Court cannot be curtailed.
Today morning it has been said.
There was a lot, I'm sorry. Lord, your lordships, my lord, would be, High Court would be dealing with either in 227, 482. But I'm sorry, my lord, today it is reversed. Your lordships have physical copy and I am, my lord, having. But I am at fault, my lord. Your lordships, I'll invite your lordships' attention only to few points, my lord. My lord, suppose in a 227 or a 482 jurisdiction, an accused approaches the court saying that there is no valid sanction. High Court is satisfied. And High Court says that till the sanction is granted, trial not to proceed. Lord, the 6 months period, my lord, the judgment takes away the discretion of the High Court to say that the stay would inure till a particular date, which is beyond the reach of the applicant. Lord, second, Lord, Indore Development Authority, my lord, a recent judgment, my lord, has recognized the principle of actus curiae neminem gravabit. Your lordships are aware, my lord, of that. Act of the court can prejudice no one.
Yes.
Lord, a somewhat similar situation was there under the new Land Acquisition Act. That period of fight by the High Court was to be excluded. And court said that it's not in the litigant's hand when the stay would be vacated, when it would be granted, modified, etc. My lord. So, my lord, that is my second point. Lord, coming to page 2 of my note, Lord, there is a Constitution Bench judgment, my lord, which Asian Resurfacing misses to note. Lord, that is Raza Buland Sugar Company versus Municipal Board of Rampur. Lord, the proposition is simple in that judgment, that nothing can be done behind the back of or in absence of the litigant.
Yes.
Lord, on 188th day, Lord, the 6 months period, matter may be on board, matter may not be on board, he would not be aware of, and by operation of the direction, my lord, the stay would get vacated. My lord, that is contrary to this Constitution Bench judgment. But at page 2, my lord, I have cited one paragraph of Sharifuddin versus Abdul Ghani loan. If your lordships can allow me to place it, my lord, para 69. So that is, my lord, in my respectful submission, fully, my lord, applicable. Therefore, it is clear that if the condition imposed by the provision of law, this was statutory law, this is continuing mandamus, to do a certain thing within a time frame is upon an institution, and the consequences of that institution not complying with the condition is to fall upon someone else who have no control over the institution, which is to perform the duty, then the provision of law cannot be construed as mandatory, but only directed. Here, the litigant has no control, and even court has no control over his list. The lists are beyond human potential. Next judgment is, my lord, Pepsi Food. Lord, there, section 254
Yes,
Well, there was an amendment in the Income Tax Act, section 254, within bracket 2 capital A was inserted. That a stay granted by the tribunal would get automatically vacated after 1 year. And High Court, my lord, this honorable court, my lord, said this, and this, my lord, I would respectfully place for your lordship's consideration. Such provision treats unequals equally.
yes,
The person who has an interim order inuring in his favor, Lord, has once persuaded the competent court to grant it. The respondent has done nothing to get that vacated. So unequals are being treated as equals, my lord. And therefore also, my lord, this needs to, my lord, this is not a correct law. Then, my lord, next point is, whenever any court, my lord, passes an order, it passes broadly, strong prima facie case, balance of convenience and irreparable injury. After 6 months, whether those conditions, these three conditions change or not, the judgment says it stays vacant without any application of judicial might. Because after 6 months, the case will not become weak. It would remain strong unless heard. Balance of convenience also would not tilt merely because 6 months have passed. And injury also, my lord.
yes.
Next point is, my lord, whenever, my lord, the judgment which Mr. Dwivedi relied upon, I also respectfully rely upon, but I'm not reading that judgment.
Yes.
Whenever a time frame is to be stipulated, it is always for the competent legislature to do.
But even those have been held to be by and large directory.
Directly. For example, my lord,
In the IBC, Insolvency and Bankruptcy Code,
IBC, my lord, or Arbitration Act.
the Consumer Protection Act.
Consumer, that after particular days, your right to file appeal goes. Because of the overall scheme of the act, the intent of the legislation, etc., etc. Because there is one focused area which the court is examining. This is not too wide an area, my lord. It can be a civil suit, it can be a criminal trial, it can be criminal revision, it can be 482, it can be civil revision under 115, it can be superintendent's jurisdiction under Article 227, but nothing is considered, and, my lord, a judicial mandamus is issued, my lord.
Generally speaking, directions for the completion of a trial proceeding by the legislature within a certain stipulated period is held to be directory. But since an appeal is a creature of a statute, directions for the legislative prescriptions for filing of appeals on limitation have been held to be mandatory.
Mandated.
Like in section 34(3) of the Arbitration Act,
Arbitration Act, my lord.
or
The
section
curtain falls.
61 of the Insolvency and Bankruptcy
Yes.
Code.
The curtain falls. You know,
Can condone a delay up to 15 days, beyond 30 days, but no further.
because time is the essence of that particular legislation. So time fixation, first of all, has to be by the competent legislature, and for the purpose of the object which that particular act seeks to achieve. It is always object specific. Then, my lord, your lordships are aware, my lord, Order 8, Rule 1 required that unless you file your written statement,
Yes.
the court can extend only for 30 days. So that came to be challenged. I will read only 4 lines when, my lord, this honorable court dealt with, my lord, the challenge. So that your lordships would find at page 4. But the citation is Kailash versus Nanku, 2005, 4 SCC 480. Para 27, only last 3 lines. My lord, that is relevant, my lord, for the entire discussion, but I don't wish to, my lord, take time on that, my lord. But last three lines are crucial. The object is to expedite the hearing and not to scuttle the same. The process of justice may be speeded up and hurried, but the fairness, which is a basic element of justice, cannot be permitted to be buried.
Last judgment, Mr. Dwivedi was the amicus, no? I wasn't paying.
So, my lord, any judicial discretion, my lord, should be left, my lord, to the concerned court, my lord, namely the High Court, and in some cases, my lord, District Court. But generally, the question of stay of trial does not arise in case of, my lord, proceedings before the District Court, for criminal division or some civil division. Generally, it is High Court.
Yes.
So, my lord, while the problem, my lord, is there, trials are stayed and it has its own ramifications, but this is not the solution. These are my respectful.
Thank you, Mr. Solicitor. Yes, Mr. Ansaria.
I appear in the IA number, my lord. 258440 of 2023. On behalf of Guwahati High Court Bar Association. And we are supporting Lord both Mr. Dwivedi and the learned solicitor, my lord. One or two aspects. Lord, wherever limitation is provided, it is upon the litigant, my lord. Lordships have, courts have put a fetter on the litigants. Section 34 Arbitration Act, appeal, and not upon the courts, my lord. If your lordship see the sweep of the directions in Asian resurfacing, my lord, in the compilation page 29. If I can read that, not 5 lines from that judgment. If your lordship go to that convenience compilation of Mr. Dwivedi, my lord, the judgment started page 3 of the compilation at page 29, just before paragraph 38. Lordship would say this sweep.
What page will that
In
be?
page 29, my lord, just starting in all pending matters before the high courts, my lords have got it.
Yes.
In all pending matters before the high courts or other courts, which will include special courts, etc., relating to the PC Act and all other civil or criminal cases, where stay of proceedings in a pending trial is operating, stay will automatically lapse after 6 months from today. The judgment is not delivered unless extended by speaking order on the above parameters. Now, next line is also important. Same course may also be adopted by civil and criminal appellate revisional courts under the jurisdiction of the high courts. The trial courts may, on expiry of the period, resume the proceedings without waiting for further intimations. But sweep of the directions, Lord, it never been, Lots would see, I'm so sorry. Lots would see the consequence on a diligent litigant, my lord. He convinces the court, passes an interim order, thereafter listed after 1 month, it does not reach, or the respondent seeks an adjournment. The court is not able to take it up despite being on the board. I wait for the entire day, my lord, it doesn't reach. It happens, my lord, in so many courts, my lord, all of your lordship knows someone, my lord. So, my lord, as learned attorney has rightly said, my lord, it is upon the institution, my lord, whether it is able to decide it or within that 6 months time limit or not.
Anything else?
And my lord, only one thing, my lord, wherever the courts find, my lord, that preemptory order is upon again the judicial discretion, my lord. Sometimes your lordships and courts pass, it will operate for a period of 6 months or, my lord, 4 weeks. So, my lord, that qualification is given, my lord, in the order itself, that this stay will operate for a period of 4 weeks and it expires automatically. That judicial discretion is available to the court, my lord, which this court, my lord, in SS surfacing so, my lord, that it automatically vacates. Wherever the court wants it, it should automatically vacate. That is stipulated in the order itself. Sometimes by your lordships, my lord, while exercising that discretion of the court, my lord. So it cannot, my lord, automatically vacate by virtue of this.
We do it so often over here, instead of saying notice returnable in 6 weeks, because if you say notice returnable after 6 weeks, sometimes we found that matters were coming back after 5 years.
Yes, my lord, it is happening.
So we list it on a particular day and say that the interim order will be up to a particular day. So we have
Yes.
control over it.
My lord, and
We know that the petitioner will also come back to us for extension of the order.
and not thereafter also sometimes it does not reach, my lord. On that particular day, it is on board, it does not reach. And the respondent seeks an adjournment, my lord, circulates a letter and gets an adjournment after. My lord,
All right.
but there are various circumstances, my lord.
All right, thank you, Mr.
I'm extremely grateful to your lordship.
Right. We've got your note here.
501.1, my lord. Lord, I respectfully adopt, my lord, all that my learned seniors before me have said, my lord. The 1 or 2 things, my lord, that I may want to add. The genesis of my matter, my lord, is a classic example of the problems with, my lord, Asian resurfacing.
Right.
This is a criminal trial. These are advocates, my lord, who appear when put in, my lord, as conspirators with the accused, my lord.
Yes.
I secured a stay, my lord, in the High Court in 2014. Matter doesn't come up, my lord. The stay now stands vacated by the orders, my lord, that I have impugned before your lordships. Only on the ground, not on the ground that I'm seeking an adjournment, not on the ground of anything else, not on the ground, my lord, that the stay deserves to be vacated for A, B, or C
Only on the
reasons.
ground of Asian resurfacing.
Only on the ground of Asian resurfacing.
Yes.
So, my lord, most of it has already been said, my lord. I'll just take a couple of minutes, my lord. May I only point out, ultimately, my lord, judicial discretion, my lord, is the essence of the adjudicatory process. What Asian resurfacing has done, in effect, is completely, my lord, taken away that discretion that the Honorable High Court, my lord, has exercised or is to exercise in respect of giving interim orders. It's
Yes.
not that an interim order is not given by without application of mind, my lord. Your lordships have already observed, and others before me have already argued, my lord, that the aspect of application of mind is taken away. What it also does, my lord, is dilutes the power of the High Court under section 482 as well as, my lord, 226.
Yes.
Finally, my lord, I'll just put it all in the note, my lord. I don't want to waste your lordship's time. The basis for Asian resurfacing, my lord, if your lordship see paragraph 36 and 37, the basis for Asian resurfacing is a judgment called Imtiaz, my lord,
Yes.
where your lordships, my lord, have discussed the delays in trials, etc. There is really no reasoning, my lord, why Asian resurfacing paragraph 36 and 37. Well, the intent, my lord, is very good. The intent, of course, my lord, is to avoid delays in trials and votes. There can be no doubt about it, my lord. But there is no specific, as Mr. Dwivedi has already argued, never arose, my lord. But I'd like to end, my lord, with what Justice Holmes said, my lord. Life of the law is, my lord, experience, not logic. Asian resurfacing is probably logic, my lord. The lordships, my lord, 5 years of experience, my lord. Grateful.
Thank you. Thank you, Mr. Pai.
Lord, Mr. Mehrotra is appearing online, my lord, if I'm permitted to address.
Anything else, Mr. Mehrotra, apart from what has been said? Yeah, please unmute yourself. You're not audible. Mr. Mehrotra, you're not audible. You'll have to. You're still muted, actually, at your end. Yes, now you're unmuted. All right, you just set your house in order. We'll hear Mr. Naski in the meantime.
But I
Mr.
appear
Naski.
in Mr. Pai's matter for the state of Andhra Pradesh, and I completely support my lord Mr. Pai in that. Not just one addition, my lord. My lord, what your lordships have done, my lord, in the judgment is that you have also imposed fetters, my lord, on the very exercise of jurisdiction. And I would only draw your lordship's attention, my lord, to a constitution bench judgment of 1964. My lord, I've passed on the judgment. It is AIR 1964 SC 1573. Your Lordship Gajendra Gadkar speaking.
What is the name of the judgment?
Lord, the name of the judgment is B. Rajgopala Naidu versus State Transport Appellate Tribunal. Lord, here,
What is the para? What para would you be referring to?
Lord, para 19 would be relevant. You know? Lord, I'm only drawing a parallel where, my lord,
We now request all members of the bar to start citing SCR. Because SCR is now up to date up to the last few
there
days.
is an SCR citation also, may I?
And with neutral citations as well.
We would certainly do that.
And now that the Allahabad High Court Bar Association is before us, ESCR has now 30,000 judgments in Hindi. All judgments of the Supreme Court since independence are being translated into Hindi. It's in a searchable format. So exactly the facility which you have available on the English SCR, you have in the Hindi SCR. So please spread the word and.
Lord, what was sought, my lord, to be done in this judgment is that by what.
And this is being now extended to other Indian languages, brother. Oak is very actively monitoring that.
Lord, what was sought to be done, my lord, in this judgment is by way of a statute, my lord. A fetter was sought to be imposed on how the quasi-judicial authority would exercise jurisdiction. But that your lordship said is not permissible. Would your lordship have para 19 minutes? May I have, sorry,
Is there, there might be there.
How does it begin?
Lord, may I just pass on the hard copy?
No, we have it here right in
Lord,
front
it
of us.
says-
You have it on your screen as well. All the lawyers will have it on your
Lord,
screen. There
in
it is.
reaching the conclusion.
Yes, we got it.
That's the one. In reaching the conclusion, we have been influenced by certain other considerations which are both relevant and material. Now the relevant part. In interpreting section 43A, we think it would be legitimate to assume that the legislature intended to respect the basic and elementary postulate of rule of law, that is, that in exercising their authority and in discharging quasi-judicial function, tribunals constituted under the Act must be left absolutely free to deal with the matter according to their best judgment. It is of the essence of fair and objective administration of law that decision of the judge or the tribunal must be absolutely unfettered by the extraneous guidance by the executive or administrative wing of the state. If the exercise of the discretion conferred on the quasi-judicial tribunal is controlled by such direction that forges fetters on the exercise of quasi-judicial authority, and the presence of such fetters would make the exercise of such authority completely inconsistent with the well-accepted notion of judicial process. So,
Yes, all right. Thank you.
just drawing a parallel.
Anything else?
Lord, Mr. Mehrotra, I don't know if he's able to come.
Mr. Mehrotra? Is someone appearing in person?
No, your lordship will then allow me to place. my-
Yes, Mr. Mehrotra.
There seems to be some.
The problem is persists, Mr. Mehrotra. If you filed your written submission, we'll read them.
Yes, right.
But that-
You have filed your written submission, we'll read those.
Yes, right.
All right. Anybody else? Are we all done?
Lord, I just wanted to add, Lord, one judgment. Lord, me too, call me, Lord, taking away of judicial discretion.
That's right. On the death penalty.
Yes, yes. Great.
I request everybody to take their seats, please. Kindly take your seats. Yes, Lordship. We request everyone to take their seats, please. We are about to start with the session 1 for the day. Good afternoon. Welcome back, everyone. Let us start with the first session of the day. It is about the 100 years of Dr. Ambedkar's enrollment as advocate. We will also reflect on his ideas of constitutionalism. The golden words of Dr. B.R. Ambedkar resonate even today. As he said, ours is a battle, not for wealth. Ours is a battle for freedom, for reclamation of human personality. Baba Sahib's thoughts, as reflected in his writings and speeches, have significant importance in tracing the history and growth of social thought in India. May I request Honorable the Chief Justice of India and Honorable Minister of State Law and Justice to release the web page on Dr. B.R. Ambedkar the architect of the Indian Constitution. Thank you, sir. I invite Dr. Uma Narayan, OSD Registrar, to give a summarized idea of this web page.
Namaskar. Good afternoon to all the dignitaries on and off the dais and all those who are present. In celebration of the centenary marking Dr. B.R. Ambedkar's admission to the bar, the Supreme Court Judges Library has developed a web page featuring numerous links. The Bombay High Court has kindly shared the digital reproduction of some original documents and judgments. The home page serves as a comprehensive introduction to the life of Dr. B.R. Ambedkar, featuring a digital representation of his portrait located in the Central Court of the Bombay High Court. The certificate page has a digital reproduction of Dr. B.R. Ambedkar's barrister certificate from Grace in London, dated 28th June 1922. The original certificate is housed in the Bombay High Court. The application page includes a concise account of Dr. B.R. Ambedkar's law practice, accompanied by the digital copy of his application to the Bombay High Court dated 25th June 1923, seeking admission as an advocate. The rear side of the application reveals that Justice Kajiji granted him advocate status on 5th July 1923. Cases, the case law page itemizes 29 cases in which Dr. Ambedkar served as an advocate. 28 in Bombay High Court, 1 in the Supreme Court, referenced from the compilation, court cases argued by Dr. Baba Saheb Ambedkar in 3 volumes by Mr. Vijay B. Gaikwad. The links to the complete text of the judgments are sourced from the All India Reporter. Some cases offer links to the original judgments of the Bombay High Court. Should I open the judgments? No, not sure. This is the scanned record from the Bombay High Court. Should I show the entire judgment? No.
Go a little slow.
Okay, sorry.
So this is a. This is a paper book of the case now. Should we go ahead?
वो पीछे वाला जो है ना, वो 28 वाला original था judgment.
Uma, you can go ahead. I think.
Yes, madam.
It's a paper book followed by the judgment.
Some original judgments are there.
Yes.
This one is there.
You can.
The next page is we have shown the Mahat Satyagraha led by Mahat Satyagraha was led by Dr. Ambedkar for right to water in 1927. The issue was only certain people were allowed to use the water from the Chowdhury tank situated in Mahat, and others were refrained to use the same. Dr. Ambedkar and his supporters led a non-violent protest for equal access of water by all. A lawsuit was filed on 12th December 1927, and Dr. Ambedkar was one of the defendants. The title of the case was Narhari Damodar Vaidya versus Dr. Bhimrao Ambedkar. In the lawsuit, the defendants, including Dr. Ambedkar, argued that the Chaudhary tank belonged to Mahad municipality and should be open to all. The trial court ruled against the plaintiffs, stating that they failed to prove a long-standing custom excluding certain group of people from using the tank, and that this custom did not qualify as a legal right. This suit was decided on 8th January 1931. An appeal was filed against the decision in the Thana court. The assistant judge Thana affirmed the lower court's ruling on 30th January 1933. Subsequently, the plaintiffs appealed to the Bombay High Court. The High Court also dismissed the appeal on 17th March 1937. After almost 10 years of struggle, Dr. Ambedkar was able to secure legal victory for his people. The digital versions of the judgments of the Mahad Court, Thana Court, and original judgment of the Bombay High Court are given in this page. There's a typewritten original judgment. Sorry. Quorum was Justice Broomfield and Justice Wadia. Here, the links to the text and the video recording of significant speeches delivered by Dr. Ambedkar in the Constituent Assembly is given. These are the PDF documents, and this is one of the YouTube links of 17 December 1946.
So far, as the ultimate goal is concerned, I think none of us need have any apprehension. None of us need have any doubt. But my fear, which I must express clearly, is this. Our difficulty, as I said, is not about the ultimate future. Our difficulty is how to make the heterogeneous mess that we have today take a decision in common and march in a cooperative way on that road which is bound to lead us to unity. Our difficulty is not with regard to the ultimate. Our difficulty is with regard to the beginning. Mr. Chairman, therefore, I should have thought that in order to make a start, in order to induce every party, every section in this country, it would be the act of greatest statesmanship for the majority party, even to make a concession to the prejudices of people who are not prepared to march with them. And it is for that I propose to make this appeal. Let us leave aside slogans. Let us leave aside words which frighten people. Let us even make concession to the prejudices of our opponents. Bring them in so that they may willingly join with us on marching upon that road, which, as I said, if we walk long enough, must necessarily lead us to unity. And if I therefore, from this place, support Dr. Jaikar's amendment, it is because I want all of us to realize that whether we are right or wrong, with our legal rights. Whether that accords with the statement of May 16th, December 16th. Leave all that aside. This is too big a question to be reduced to the position of mere legality. It is not a legal question. I say leave aside all these considerations and make some attempt whereby those who are not prepared to come will come. Let us make it possible for them to come. That is
The subsequent page showcases the books and publication authored by and about Dr. Ambedkar, available in the Judges Library, Supreme Court. Additionally, two links are given to the websites where the digital version of his writings and speeches are provided. Finally, there is a photo gallery displaying important images sourced from the website drambedkar.co.in. We are confident that this web page will be beneficial for all those interested in gaining insights into Dr. Ambedkar's legal journey. Thank you.
Thank you, ma'am, for a touching showcase. It was wonderful indeed. May I now request Honorable Chief Justice of India to present a memento to Honorable Minister of State, Law and Justice. May I request Honorable Chief Justice of India to also present a copy of Gender Handbook, Supreme Court Chronicle, a newsletter from Supreme Court, and report on state of the judiciary to the Honorable Minister. Thank you, sir. May I request Honorable Minister of State, Law and Justice, Shri Arjun Ram Meghwal, to address the audience.
Honorable Chief Justice of India, Dr. न्यायमूर्ति D.Y. चंद्रचूड़ साहब और श्री न्यायमूर्ति B.R. गवई साहब, जज ऑनरेबल सुप्रीम कोर्ट ऑफ इंडिया, विशिष्ट सभी अतिथिगण, देवियों और सज्जनों, पहले तो मैं CJI साहब को धन्यवाद देना चाहता हूं कि मैंने बातों बातों में कोई विषय रखा और इस विषय को इन्होंने आज यहाँ पहुंचा दिया और आज सुप्रीम कोर्ट में अपने एक टेक्निकल सेशन में इसी विषय पे चर्चा कर रहे हैं। CJI साहब, आपका बहुत बहुत बधाई और बहुत बहुत धन्यवाद। बहुत ही सुंदर कार्यक्रम आपने हाथ में लिया। दो और धन्यवाद देना चाहता हूँ। मुझे पता नहीं कि किस तरह की इन्होंने मेहनत की होगी रात और दिन, क्योंकि हम 3-4 महीनों से इसको डिस्कस कर रहे थे। एक है डॉक्टर उमा नारायण, अभी अभी बोल रहे थे आपको, इनके लिए भी जोरदार तालियां बजनी चाहिए। और एक है अनुराग भास्कर, वो इधर खड़ा है, इधर खड़ा है, हाँ इधर खड़ा है। इनके दोनों के लिए थोड़ा जोरदार ताली बजाओ, बड़ी मेहनत की इन्होंने, बाकी काफी मैं चर्चा में था। अभी आवाज सुनी हमने बाबा साहब भीमराव अम्बेडकर जी की, सब्जेक्ट आपके सामने है। मैं 2-3 चीजें आपको कहूंगा। आवाज भी बहुत शानदार है। ये विषय है 9 दिसंबर 1946 को हमारी संविधान सभा बैठी, तो उसमें 299 जो मेंबर थे हमारी संविधान सभा के, वो सब सम्मिलित हुए, लेकिन उसमें सम्मिलित होने थे उसमें, लेकिन उसमें राजाओं के प्रतिनिधि नहीं आए और मुस्लिम लीग ने बाइकाट किया। तो उस समय एक हमारे संविधान का उद्देश्य क्या होगा, उसके लिए प्रस्ताव रखा पंडित नेहरू जी ने। तो कुछ लोगों ने कहा अभी चर्चा करो, कुछ लोगों ने कहा अभी चर्चा मत करो। लेकिन बाबा साहब डॉक्टर अंबेडकर का जो एक लीगल बैकग्राउंड था, उसके आधार पर वो लॉजिकल बात करते थे, और लॉजिक सबको बाद में उस समय समझ में आया। जो भी आप भाषण जो सुना रहे थे, ये 17 दिसंबर 1946 का है। पहले पे विवाद हो गया, किसी ने कहा कौन बोलेगा कौन नहीं बोलेगा। फिर चर्चा हुई कि जो MR जैकर ने एक प्रस्ताव रखा कि जब तक मुस्लिम लीग नहीं आई, वो पूना से आते थे, जहां से हमारे ऑनरेबल चीफ जस्टिस ऑफ इंडिया महाराष्ट्र से आते हैं, वहीं से महाराष्ट्र के ही MR जैकर थे, अच्छे वकील थे। उन्होंने कहा कि आप जो ये बात है कि मुस्लिम लीग जब तक नहीं आए और राजाओं के रिप्रेजेंटेटिव भी आने थे, तब तक आप नहीं चर्चा करो तो ठीक है, वो समर्थन किया। लेकिन नेहरू जी का प्रस्ताव था कि अभी चर्चा करो। अब देखिए, उस समय नेहरू जी के मानने वाले बहुत लोग, कॉन्स्टिट्यूंट असेंबली में भी बहुत लोग, उस पीरियड में सबसे पहले सच्चिदानंद जी थे हमारे कॉन्स्टिट्यूशन संविधान सभा के अध्यक्ष, लेकिन उसके बाद डॉक्टर राजेंद्र प्रसाद चुन लिए गए थे। तो राजेंद्र प्रसाद जी ने सोचा कि डॉक्टर अंबेडकर बहुत लॉजिकल बोलते हैं, इनको शुरू करें क्या। कोई चर्चा करना तैयार नहीं था। तो 17 दिसंबर को जब बाबा साहब डॉक्टर भीमराव अंबेडकर खड़े हुए, तो जो उनका भाषण है, उस भाषण ने उनको अमर कर दिया, उस भाषण ने ही अमर कर दिया। आदिश अग्रवाल जी जोर से ताली बजा रहे हैं, जोर से बजाओ फिर तो बजा रहे हो तो। हाँ। क्या कहा उन्होंने कि कितनी छावनी बनाओगे भाई, हम संविधान सभा में बैठे हैं, हॉल एक है, लेकिन इसमें भी छावनियां हैं। कोई कहता मैं मराठा हूं, कोई कहता मैं पंजाबी हूं, कोई कहता मैं मद्रासी हूं, कोई कहता मैं ये हूं, कोई कहता मैं ये हूं। हम जातियों में भी बंटे हैं, धर्मों में भी बंटे हैं, क्षेत्र में भी बंटे हैं। ये देश को ऐसे एक कैसे करेंगे अपन। जैसे ही बोलने खड़े हुए लोगों ने कहा ये तो कुछ और बोलने वाला था, इसका चरित्र तो ऐसा होना चाहिए, इसका चरित्र ऐसा होना चाहिए, आज हम इसकी हुटिंग करेंगे, इसको बोलने नहीं देंगे। लेकिन जैसे ही पहले ये शब्द यूज किया कि हम देश में भी छावनियों में बैठे हुए हैं, या हम संविधान सभा में भी छावनियों में बैठेंगे क्या हमें देश को एक नहीं रखना। अगर आपको देश को एक रखना है तो मेरा मानना है कि MR जैकर ने कोई गलत बात नहीं की है, आप उसको बोलने नहीं दे रहे। MR जैकर भी बड़ा आदमी है। तो जैसे ही अंबेडकर बोलते गए 1 घंटा से ज्यादा का भाषण है, कितनी बार तालियां बजी। सरदार पटेल पहली बार प्रभावित हुए कि यार ऐसे बोलते हैं क्या डॉक्टर अंबेडकर। ये वकील के कारण बोल रहे हैं। 2-3 घटनाएं वकील की मैं बताऊंगा। उसके बाद जो 17 दिसंबर का जो भाषण था, उसके बाद ये आपका जो बांग्लादेश जहां से सुन के आए थे, वो एरिया, वो एक रेड कौन सा आया था, एक अंग्रेज आया था ना, आदिश अग्रवाल जी, रेड क्लिफ नहीं, हाँ रेड क्लिफ, वो आया था। तो उसने वहां कराची में बैठ करके पता नहीं देश का नक्शा खींचा कि 50% से ज्यादा आबादी कहीं होगी मुसलमानों की, वो एरिया पाकिस्तान में जाएगा, बाकी हिंदुस्तान में रहेगा। तो जहां से बाबा साहब चुन के आए थे, वो आबादी तो 48% थी मुस्लिम समाज की। अभी जो बांग्लादेश है, बंगाल से आए थे, लेकिन वो एरिया चला गया पाकिस्तान, पूरी पाकिस्तान, अब बांग्लादेश है। तो ये तो बिना मेंबर के ही रह गए। डॉक्टर अंबेडकर संविधान सभा में नहीं आए। उन्होंने कहा इनका एरिया तो गया ये पाकिस्तान में। अब ये पाकिस्तान में, उन्होंने कहा मैं पाकिस्तान नहीं जाता, मैं हिंदुस्तान में रहूंगा। जोगेंद्र मंडल ने कहा पाकिस्तान आ जाओ, उन्होंने कहा मैं पाकिस्तान नहीं जाता, मैं हिंदुस्तान में रहूंगा, हिंदुस्तान को एक रखूंगा, हिंदुस्तान को महान बनाऊंगा, हिंदुस्तान की संस्कृति को प्रमोट करूंगा। तब उन्होंने कहा यार ये तो ऐसे आदमी हैं। तब फिर MR जयकर, कितना बड़ा त्याग था उस समय MR जयकर साहब का, लोग भूल गए, किताबों में लिखा नहीं ढंग से। MR जयकर साहब ने इस्तीफा दिया आपके स्टेट से, मराठा से, उन्होंने सीट खाली की। उस सीट पे भी कई लोग की नजरें रहती है, जैसे आपके यहाँ कोई सीट खाली हो जाती है, हमारे यहाँ की सीट नजरें तो रहती है। तो उस सीट में भी कई नजरें रही। सुनीता जी, आप भी जोर से हंस रहे हो ना बहुत, सुनीता जी के लिए ताली बजाओ भाई, इतना आनंद आ रहा। मैं इसलिए बजा रहा हूँ, ये हैप्पीनेस है जी, हम हंसते ही नहीं है जी, इसके लिए तो कोई बजट लगता ही नहीं है ना, इसमें क्या दिक्कत है। तो उसके बाद उन्होंने कहा क्या करना चाहिए, तो एक खरे कोई आपके चीफ मिनिस्टर थे बॉम्बे, क्यों कवि साहब आपको आइडिया होगा, खरे खेर वीजी खेर, उनको चिट्ठी लिखी, वो मैंने अभी नेहरू लाइब्रेरी से निकाल ली, उनको चिट्ठी लिखी सरदार पटेल साहब ने कि 17 दिसंबर के भाषण के बाद मेरा थॉट डॉक्टर BR अम्बेडकर के प्रति बदला है, अगर कोई और टिकट मांग रहा है वहां से तो किसी को मत आने देना, तुम डॉक्टर अम्बेडकर को ही चुन करके भेजना। इसलिए डॉक्टर अम्बेडकर संविधान सभा में आए। उसके बाद तो आपको पूरी हिस्ट्री पता है, ड्राफ्टिंग कमेटी के सदस्य बने, उसके बाद चेयरमैन बने, अब ये वकील 1923 में बने। वकील की जो भूमिका होती है वो हर जगह रही उनकी। अभी कुछ जो डॉक्टर उमा नारायण ने जो चीजें हमें दी, ये एक इनिशियली स्टेज के एडवोकेट के रूप में चीजें थी। एक घटना, कितना CJI साहब मेरे पास टाइम कितना है, तो ज्यादा टेक्निकल सेशन ही है, 5-7 मिनट है अभी, और क्या 5 मिनट है। एक घटना मैं बताता हूं, चलो उस घटना को फिर छोड़ता हूं, मैं स्किप करता हूं क्योंकि जिस दिन से इंडिकेशन है। लेकिन एक और अच्छी घटना है जो मैं आपको बताता हूं। वकील के रूप में वो बहुत फेमस हो गए कि ये गरीब जो लोग होते हैं, जो लेबर क्लास है, उनके केस ये फ्री में लड़ते हैं। ऐसे बहुत बड़ा नाम था डॉक्टर, और ऐसा एक केस फ्री में लड़ा एक सुरई को, हमारे महाराजा को लेकर, वो मैं आपको बताना चाहता हूं। कई बार अपने को पता रहता है भी, पता चलता है ऐसे कैसे हो गया। एक समिति थी साहब संविधान सभा में, जिस समिति का नाम था राष्ट्र ध्वज समिति थी। वो राष्ट्र का ध्वज कैसा हो, उसको लेकर एक समिति थी। उस समिति में जब बहस हुई, ये सदस्य तो काफी थे, लेकिन जब बहस हुई समिति में, अब ये पन्ना कहीं इधर उधर हो गया, लेकिन मैं बताता हूं। चरखा, 3 रंगों का अपना ध्वज है ना, इसमें ही मेंबर थे डॉक्टर अम्बेडकर। तो किसी ने कहा कि जो पुराना जो चरखे वाला है यही रख दो झंडा। बोलते गए, डॉक्टर अम्बेडकर ने भी कहा चरखा के अलावा और कुछ हो सकता है, तो 3 रंग का अपन झंडा मानते हैं, हमारा झंडा जो है तिरंगा है। लेकिन उसमें एक चौथा रंग भी है, मसीह साहब ठीक कह रहे हैं, चौथा रंग भी है, वो ब्लू कलर का अशोक स्तंभ है ना। तो धम्म का एक प्रतीक उनको लेना था, तो चरखे पे डिमांड चल रही थी। किसी की आई बात के स्वस्तिक कर दो, हमारा ये भारतीय संस्कृति के हिसाब से स्वस्तिक अच्छा, बीच में स्वस्तिक डाल दो। अब यहां जब चरखा आया तब चरखे पे डिमांड चलती थी कि चरखा ठीक है, 24/7 चलने की बात भी करता है, चरखा ठीक है। और चरखा कई कांग्रेसी चाहते थे और कहते थे महात्मा गांधी का थॉट भी उसमें आ जाए। लेकिन डॉक्टर अम्बेडकर खड़े हुए, उन्होंने कहा जी चरखे के अलावा मैं एक सुझाव देता हूं। उन्होंने कहा वो क्या सुझाव है? उन्होंने कहा कि हमारे एक दिन में 24 घंटे होते हैं, ये जो आपका धम्म का चक्र है सम्राट अशोक का, इसमें 24 चक्र है, 24 वो दालियां, और 24 ही घंटे होते हैं। और हर जो दालियां क्या बोला उन्होंने, डंडिया, उस पे एक गुण है। जैसे एक गुण है प्रेम, एक गुण है दया, एक गुण है करुणा, ऐसे 24 गुणों का जिक्र किया। और नेहरू जी को समझाया, सरदार पटेल को भी समझाया कि ये जो झंडा है ये खाली झंडा नहीं होता है, ये देश का एक प्रतीक होता है। जैसे हमारी करेंसी हमारा प्रतीक है, हमारा झंडा हमारा प्रतीक होगा, हमारा संविधान हमारा प्रतीक होगा, हमारी सेना हमारी प्रतीक होगी, संप्रभुता को रिफ्लेक्ट करेगा ये झंडा। इसलिए झंडे में ऐसा एक चिन्ह दो जो हमारी संस्कृति से भी जुड़ा हुआ हो और लोग उसको लाइक करें। तो उन्होंने कहा क्या है ऐसा, तो उन्होंने जैसे ही अशोक चक्र का जिक्र किया, धम्म चक्र का जिक्र किया और उसको महात्मा बुद्ध से जोड़ा और कहा कि इसमें 24 गुण है। तो मनुष्य झंडे को देखेगा तो उन 24 गुणों को स्वीकार करेगा। मुझे दया आनी चाहिए, मुझे करुणा आनी चाहिए, मुझे प्रेम, मेरे में प्रेम रहना चाहिए, मैं लड़ाई नहीं करूं ऐसा मेरे में गुण आना चाहिए। 24 गुणों को वो इंडिकेट करेगा और ये 24x7 को भी इंडिकेट करेगा। घंटे भी 24 हैं और इसमें तिल्लियां भी 24 हैं। और आप मेहनती नागरिक बनाने के लिए आप इसमें चरखे की बजाय ये अशोक स्तंभ डाल दो। और सारे सदस्यों को एग्री कराया। फिर किसी ने पूछा कि यार ये हो तो चरखा रहा था डॉक्टर अम्बेडकर, आपने इसको ऐसे कैसे डलवा दिया? तो उन्होंने कहा मैं एडवोकेट हूं, मुझे पैरवी करनी आती है, मैं एडवोकेट हूं बेसिकली, मुझे पैरवी करनी आती है। और जब मैं खड़ा हुआ यहां तो मैंने देखा यहाँ मेरा जो लीगल बैकग्राउंड है वो काम आएगा कि नहीं आएगा। ऐसी जोरदार पैरवी की कि वो झंडे में अशोक जो धम्म चक्र है वो आ गया और अपना झंडा वैसे तिरंगा है लेकिन रंग 4 है साहब उसमें, ये नीले रंग का अशोक चक्र भी है, लेकिन इसको हम ग्रहण नहीं करते। इसमें 24 गुण है। को देके जाऊंगा, वो मुझे यहाँ पन्ना नहीं मिल रहा है। 24 गुण उसमें कौन कौन से हैं? प्रेम, करुणा, दया, कर्तव्य निष्ठा, जो हमारे इसमें डायरेक्टिव प्रिंसिपल स्टेट में है, इसी काम करना चाहिए और देश का हम श्रेष्ठ नागरिक बने। झंडे को देख करके भी हमें गुण आना चाहिए। कोई हमें गुरु ज्ञान देकर के हमारे में गुण प्रवेश करवा सकता है, लेकिन क्या झंडा भी हमारे में गुण प्रवेश करवा सकता है क्या? ये भाव अगर किसी ने रखा संविधान सभा में तो डॉक्टर बी.आर. अम्बेडकर बाबा साहब ने रखा। इसलिए हम एज एन एडवोकेट जो उनके काम है उनका जिक्र कर रहे हैं और ये संविधान में रिफ्लेक्शन हुआ। अब एक चीज मुझे याद आई गई, इसलिए 2 मिनट और लूंगा। एक विषय आया मताधिकार का, तो विषय चला कि इस देश में तो अनपढ़ लोग हैं, इस देश में गरीब लोग हैं, वो वोट का मतलब ही नहीं जानते। ऐसा करो जैसे कोई नगर सेठ है हमारे देश में, वो 1 वोट देवे और 20,000 गिन लो। कोई राजा है वो 1 वोट देवे और 50,000 गिन लो। कोई बड़ा राजा है तो 1 वोट देवे 1 लाख गिन लो। ऐसे करके 22 करोड़ के करीब मतदाता थे उस समय। तो 22 करोड़ पूरे हो जाएंगे, सबको वोट मत दिलाओ और महिलाओं को तो दो ही मत। और उस समय तो अमेरिका को भी महिलाओं को लेट मिला मताधिकार, इंग्लैंड में भी लेट, अमेरिका में भी लेट। तो यहां जल्दी क्यों देते हो? तो उस समय डॉक्टर अम्बेडकर खड़े होते हैं, या फिर एडवोकेट का काम करते हैं डॉक्टर अम्बेडकर, पैरवी करते हैं। जो बोल नहीं पा रहे थे वो संविधान सभा में नहीं आ पा रहे थे, अनपढ़ लोग, गरीब लोग, वंचित लोग, महिला, खाली 15 महिलाएं थी, उन्होंने भी स्वीकार कर लिया ठीक है बाद में दे देना। लेकिन डॉक्टर अम्बेडकर खड़े होकर के उन्होंने नेहरू जी की तरफ देखा और नेहरू जी को कहा कि पंडित नेहरू थोड़ा मेरी तरफ देखिए। उन्होंने कहा क्या? कि ऐसा मत करिए, पाप हो जाएगा। अडल्ट फ्रेंचाइज, मताधिकार सबके लिए एक साथ करिए। बोला क्यों? कि अभी आप कह रहे थे मुझे 2 घंटे पहले कि मैं एशियन और अफ्रीकन देशों का लीडर बनना चाहता हूं और इंडिया लीडर बन सकता है। तो हमारे बाद जो देश आजाद होंगे अफ्रीका और एशिया के, कुछ नया हम नहीं देंगे तो हमसे क्यों वो ग्रहण करेंगे? आप अगर नया देना चाहते हो तो मैं कहता हूं एक साथ मताधिकार दे दीजिए, गरीब को भी, अमीर को भी, महिला को भी, पुरुष को भी, पढ़े लिखे को भी और अनपढ़ को भी। आप मताधिकार एक साथ करके देखिए, आप बहुत बड़े लीडर बन जाओगे और एशिया और अफ्रीका में पूजे जाओगे। तो नेहरू जी भी समझ में आ गया यार बात तो ठीक कह रहे। तो तर्क इतने मजबूत थे वकील के नाते कि नेहरू जी भी माने, संविधान सभा के दूसरे सदस्य भी माने और एक साथ मताधिकार मिला सबको, भारत में ही मिला। अदरवाइज तो हो सकता महिलाओं को मताधिकार कोई 10-20 साल बाद मिलता, 30 साल बाद मिलता। उन्होंने कहा एक साथ दो। उन्होंने कहा नहीं क्या करना है, पुरुष जो सोचेगा वही महिला सोचती है। बोला नहीं, महिला अलग से भी सोचती है, गरीब आदमी अलग भी सोचता है, और उन्होंने एक चीज और कही कि नेहरू जी, जब ये लोग मताधिकार का प्रयोग करने जाएंगे तो जैसे ये होली और दिवाली मनाते हैं ऐसे ये सेलिब्रेट करेंगे। सब हंसे कि ये क्या कह रहे हो डॉक्टर अम्बेडकर। आज मैं देखता हूं, जब कभी चुनाव में जाता हूं, कोई ग्रामीण महिला आती है, सच धक कर आती, पूछता हूं कहां जा रहे हो, वोट देने जाऊं। तो वो जो वोट देने जा रहे हैं और सच धक के जा रहे हैं, सेलिब्रेशन के रूप में जा रहे हैं, जैसे होली और दिवाली मनाएंगे, जैसे डॉक्टर अम्बेडकर ने कहा था, ऐसे आज भारत में जो लोकतंत्र मजबूत हुआ है उसका बड़ा कारण मताधिकार है। मुझे आपने बोलने का अवसर दिया, उसके लिए आपको बहुत बहुत धन्यवाद। थैंक यू।
Thank you, Honorable Minister, for sharing interesting facts and enlightening us. May I now request Honorable Shri Justice B.R. Gawai to address the audience.
The Honorable Chief Justice of India, Dr. Justice D.Y. Chandrachud, my esteemed colleagues on the bench in the Supreme Court of India, the Honorable Minister of State for Law and Justice, Shri Arjun Ram Meghwalji, the Honorable Chief Justices and Judges of the High Courts, registrars and members of the audience. Today is a historic day. It is so because on this day in 1949, we as an independent nation adopted the Constitution of India. But today's date is historic for two more reasons. The first reason is that earlier today, the Honorable President of India unveiled the statue of Dr. B.R. Ambedkar in the premises of the Supreme Court of India. I have no manner of doubt that today's day will be written with golden words in the history of the Indian Supreme Court. I thank and congratulate the Honorable Chief Justice of India from the bottom of my heart for taking the decision to have a statue of Dr. Ambedkar in the Supreme Court. Dr. Ambedkar had famously called Article 32, which provides the right to Indian citizens to approach the Supreme Court, as heart and soul of the Constitution. The statue of Dr. Ambedkar is facing the court number 1, that is the Chief Justice's court. By placing the statue in front of the court number 1, we have paid homage to Dr. Ambedkar as well as reaffirmed his idea that the right to approach the Supreme Court is indeed the heart and soul of the Constitution. Today's day is also historic for a second reason. We are celebrating the centenary of Dr. Ambedkar's enrollment as an advocate. Dr. Ambedkar finished his study of law from Gray's Inn in London in 1922. After his arrival to India in 1923, he had applied for a license to practice law. Dr. Ambedkar had enrolled as an advocate and started practicing before the Bombay High Court in July 1923. The fruits of constitutionalism which we cherish today were sown by Dr. Ambedkar a century ago. I had the fortune of inaugurating a court at Mandangarh in which Dr. Ambedkar's native village, Ambode, which is situated along with the Honorable Chief Justice of Bombay High Court, Justice Devendra Upadhyay. Born into a society marked by deep-rooted social hierarchies and discrimination, Dr. Ambedkar faced adversity with unparalleled challenge and courage. Dr. Ambedkar's writings since 1919 focus on the recognition of equal rights for all the citizens. He emphasized on interconnection between rights, citizenship, and constitutionalism. He theorized citizenship as a bundle of rights, which include fundamental rights and the right to participate in a democracy. Dr. Ambedkar aimed at shaping the discourse of the society through constitutionalism. He attempted to address the social problems through the framework of law and the Constitution. It is for this reason that is emphasized on having detailed provisions in the Constitution so that there is no scope of arbitrariness in the actions of the decision makers as well as the society. Dr. Ambedkar's constitutional ideas were not limited to lawmakers and judges. He envisaged a public discourse on the values of the Constitution. He had once pointed out that fundamental rights provided by the Constitution ought to be protected by the social conscience of the citizens. That is, the citizens need to respect the fundamental rights of their fellow citizens. Dr. Ambedkar was also a strong proponent of constitutional traditions and practices. He believed that constitutional practices which may not be entrenched in the text of the Constitution are conditions precedent for the successful working of a democracy. He therefore hoped that citizens and constitutional authorities would respect the constitutional traditions. Today, the Supreme Court has also launched a web page on the centenary of Dr. Ambedkar's enrollment as advocate. The web page contains a list of cases argued by Dr. Ambedkar. This web page will act as a source of great knowledge for the common citizens and a valuable resource for scholars and researchers. The most celebrated case in which Dr. Ambedkar participated is the case to enter the Chaudhar tank in Mahad in Maharashtra. In 1923, S.K. Bole, a social reformer, moved a resolution in the Bombay Legislative Council which provided that untouchable classes be allowed to use all public watering places, which are built and maintained out of public funds. Thereafter, the Mahad municipality passed a resolution to open the Chaudhar tank for depressed classes. However, the municipality's resolution could not be implemented due to opposition from the oppressor caste of that area. In March 1927, Dr. Ambedkar led a group of individuals belonging to the oppressed caste and drank water from the tank to assert their right of equal access to public resources. This movement is celebrated as the Mahad Satyagraha. However, due to retaliation and pressures from the oppressor caste, the Mahad municipality in August 1927 revoked its resolution to allow the untouchable community to access the tank. Thereafter, Dr. Ambedkar again called for a conference in Mahad in December 1927. However, before the conference could take place, the caste Hindus filed a civil suit for injunction against Dr. Ambedkar and his associates to restrain them from entering the tank. The plaintiff claimed that the tank was a private property. A temporary injunction was granted by the court. Dr. Ambedkar then decided to take up the legal battle, which went on for almost a decade. I am glad that the Supreme Court Judges Library has acquired the original case records pertaining to Mahad Satyagraha and has uploaded it on the web page. In the Mahad case, Dr. Ambedkar, strategically planning his defense, successfully argued that the tank was a public asset and should be accessible to all the segments of the society equally. In its ruling, the Mahad Court ruled that the plaintiffs could not establish ownership of the tank. Both the appellate courts, including the Bombay High Court, ruled in favor of Dr. Ambedkar. Among other notable cases, Dr. Ambedkar in 1934 successfully defended the All India Textile Workers Conference by exposing the shortcomings in the Trade Disputes Act of 1921. He also provided a legal defense for Dr. R.D. Karve, who faced charges of obscenity for his work, Samaj Shastra, a publication on sexual hygiene. Dr. Ambedkar had several quibbles with the social inequalities prevalent in 19th century India, the evils of which he had suffered greatly. This, however, never made a dent in his zest for patriotism and nationalism. He was a patriotic to the core. It will be apt to quote from his speech made on 17 December 1946 at the Constituent Assembly. And I quote, "While deciding the destinies of nation, dignities of people, dignities of leaders, and dignities of parties ought to count for nothing. The destiny of the country ought to count for everything." Unquote. Furthermore, Dr. Ambedkar was of the firm belief that a constitutional democracy formed on the bedrock of inequality would never truly prosper. In his ironic speech that could not be delivered but was later published, The Annihilation of Caste, he mentioned that an ideal nation can only be built with the ideas of liberty, equality, and fraternity. It is his brainchild that India embraced the trinity of liberty, equality, fraternity into the text of the Constitution. On 25th of November 1949, on presenting the Constitution, he warned that there were a lot of contradictions present in political and social life, and if left unchecked, they would put the foundational democracy of India in peril. In his words, and I quote, "On the 26th January 1950, we are going to enter into a life of contradictions. In politics, we will have equality, and in social and economic life, we will have inequality. In politics, we will be recognizing the principle of one man, one vote, and one value. in our social and economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. How long shall we continue to live this life of contradictions? How long shall we continue to deny equality in our social and economic life? If we continue to deny it for long, we'll do so only by putting our political democracy in peril. We must remove these contradictions at the earliest possible moment, or else those who suffer from inequality will blow up the structure of the political democracy which this assembly has laboriously built up. Dr. Ambedkar believed that we not only need a system of political democracy, but also a social democracy. He said, and I quote, political democracy cannot last unless there lies at its base the social democracy. Today, it is essential to recognize that Dr. Ambedkar's mission is far from complete. His ideals remain a beacon, guiding us through contemporary challenges and inspiring us to confront issues of inequalities that still persist in various forms. On this day, the best way to pay tribute to him would be to take a pledge that we leave no stone unturned in giving effect to the dream of Dr. Ambedkar and the other framers of the Constitution of India for ensuring that the country achieves social and economic equality along with political equality. Thank you. Thank you very much.
Thank you, sir, for throwing light on Baba Sahib's life and inspiring us. We would like to acknowledge the dedication and artistic skills of Shri Naresh Kumar Kumawat in crafting the sculpture of Dr. B.R. Ambedkar in record time, which has been unveiled by the Honorable President of India today in the premises of the Supreme Court. We also acknowledge the tireless efforts of Shri Purnesh Kumar, Project Director, Supreme Court Project and Maintenance Circle, CPWD, for timely completion of installation of this sculpture. I request Honorable Chief Justice of India to give the certificate of appreciation to Shri Naveen Kumar Kumawat and Shri Purnesh Kumar for their commendable work. Thank you, sir. May I now request the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, to address the audience.
My very distinguished colleague, Justice Bhushan Gawai, who since my days is a judge of the Bombay High Court, I fondly referred to as HMJ. I was Mr. Arjun Ram Meghwalji, Union Minister of State for Law and Justice. But let me first begin on a lighter note. I was telling Meghwalji about why I call Justice Gawai HMJ. And the reason is that in the Bombay High Court, whenever you attend a public function, the names of the judges, instead of putting for everybody Honorable Ms. Justice, Honorable Mr. Justice, or everything in Mumbai is in short forms, right? Mahatma Gandhi Road becomes MG Road. So everything becomes in short form because the city is always on the move. So they write HMJ. So when he became a judge, we decided to call him HMJ. So he has continued to be HMJ since the first day that he became a judge and right now. I had a prepared speech really, but I thought, we're in a post-lunch session and we have heard two excellent speeches from Mr. Meghwalji first and then thereafter from Justice Gawai. But thank you all of you for joining in. All my distinguished colleagues are here from the Supreme Court. I know it's it's really a day of rest otherwise for them that they've all come here. And I sincerely thank all of my colleagues who are here in the audience, Chief Justices of the High Courts who are here, judges of the computer committees. This session is in itself very important, but I think this session is not just about the fact that we have set up the statue, but there is something far more profound in the reason why we have set up this statue and what is going to follow now. In a way, Dr. Ambedkar really belongs to all of us. I think gone are the days when we can say that people called him the leader of the untouchables. He is not a leader of the untouchables. He represents really the entire nation. He represents the voice of the nation. And the more one reflects on the life and times and teachings of Dr. Ambedkar, one realizes that his effort was not just to bring about a measure of social reform or to mobilize his own people for whom he led the cause of social justice, but this was essentially an effort to reform Indian society itself. That's why I always believe that while on the one hand, India is, ever since the time of just Dr. Ambedkar, facing these and witnessing these large social reform movements of mobilization. And we as judges see how our court is being used for engaging in a public discourse on various aspects of marginalization. Yet I always do believe that bringing social justice to the marginalized is not a project of the marginalized alone. Just as I always believe that bringing gender justice is not a project for women or for or those who are in that sense at the receiving end of the spectrum, but it's a project for all of us. And in that sense, I think we are all reforming ourselves and we are healing ourselves in our effort to heal the society. So Dr. Ambedkar didn't really stand away from society. He didn't treat himself as a leader of a community of persons, the Bahujan Samaj, which was discriminated against for centuries. But he regarded himself as part of the mainstream of Indian society. And as a part of that mainstream, attempted to reform what he regarded was years and years of discrimination. So in that sense, the statue which the Supreme Court has set up today, it represents the abiding quest for equality in our society. Because the most fundamental of values in the Constitution are represented by equality and fraternity. Liberty without equality and fraternity would really be only a hoax. Therefore, it is when you have conditions of equality, when you have a condition of fraternity, that you can truly aspire for true liberty. The setting up of this statue, this afternoon session, originated in a number of conversations, which I must acknowledge. I think I've unfairly received too much of the share of the credit since the morning for what has happened this morning. When Mr. Arjun Ram Meghwal became Union Minister, and we have wonderful conversations with him on the state of the judiciary, appointments, transfers, budget, infrastructure, technology, we normally finish our work in about 20 minutes to a half an hour. But thereafter, on a Sunday afternoon, the rest of the 1.5 hours is talking about just society, ideas, vision. And he really put this thought in my mind. He said that Dr. Ambedkar completes 100 years of his enrollment as a lawyer. So why doesn't the Supreme Court plan on doing something on the occasion? I must also acknowledge here the Union Minister was very gracious to ask both Uma and Anurag to stand up. A lot of these ideas have been shaped by my abiding conversations with Anurag. Anurag was my young intern when I was Chief Justice of the Allahabad High Court, and Justice Deven Upadhyay is here, Chief Justice of the Bombay High Court. And Deven brought Anurag one day to my chamber at Lucknow and said, I brought my young intern to come and meet you. So I had a conversation with him, and then he interned with me. When I came to the Supreme Court, again, he came and interned with me. He thereafter clerked with me in the Supreme Court. Anurag himself belongs to the Bahujan Samaj. Anurag one thing which I was always very struck by was his wide readership. The amount he read, he had a ton of books when his internship and law clerkship with me came to an end. About 4 or 5 young interns and lawyers in the law clerks all went with him carrying these tons of books with him. Anurag applied for a scholarship to the Harvard Law School. He was admitted to the LLM program of the Harvard Law School. He did brilliantly at the Harvard Law School and then came back and, of course, joined as a professor at the Jindal Global Law University. But he and I had a contract, and he said that, well, I'd come one day and come and work at the Supreme Court. And he's now part of our revamped Center for Research and Planning. A very fascinating person I met recently during my travel to the US was a young woman called Disha Wadekar. And Disha belongs to one of those criminal tribes who were criminalized in India, the Parthi tribe. And we know, coming from Maharashtra, what tremendous prejudice that the tribe faces. And she has got admission for an LLM at the Columbia Law School. And I had this very long and sustained engagement with her. And both Anurag and Disha were together at this program, which I was invited to deliver the annual Ambedkar Memorial Lecture at the Brandeis University. Brandeis, by the way, has a bust of Dr. Ambedkar. And Disha said something which really, really struck me in my mind as we were in one of those sessions. And she says, were it not for affirmative action, I would not be here today where I am. Because that has given me a platform to compete on an equal footing. I would also really like to express my deep gratitude to both Justice Sanjeev Khanna and Justice Bhushan Gavai for the statue which has come up. I had just the idea, but honestly, a Chief Justice can implement only something that his colleagues are supportive of. So when I broached it with both Sanjeev and Bhushan in the morning, and I said, well, I've constituted this committee and I'd like you to both get started. The Union Ministry of Culture, which is of course also led by Meghwalji, they gave us all the assistance. We selected the best of these sculptors in the country. And the sculpture has been put up, the statue has been put up in record time. We also had construction workers in the Supreme Court who have worked day and night to install this. When I got videos of the statue being lifted on a crane and installed, I had the worst nightmares, but the crane was very strong, though the statue was also very heavy. It had to be a heavy statue of one of the most distinguished constitutional experts that India has known. My gratitude to the Center for Research and Planning, to Dr. Uma Narayan and to Sukhada Pritam and everyone there. But I'll be failing in my duty if I didn't tell you that the statue was actually put up last night or early this morning at 3 o'clock. The final finishing touches were completed only at 3 o'clock this morning because we were battling because there were construction restraints in Delhi. So we had to be compliant with all of those activities. And I would like to particularly congratulate my entire team. The Secretary General Atul Kurekar is here. He was here till 3 o'clock last night. Mr. Mahesh Patankar should be here. I hope Mahesh is here. Mahesh Patankar, who worked ceaselessly and was sending me videos all through the night to tell me what is the stage of the installation. So really, this Mr. Rakesh Sharma, our registrar, who has been looking after this entire one-day event. So I thank all of you, my team, which has done what they have done. In the course of the speech by the President today, the President underlined very important aspects of our profession. And she said, what can we do to make our profession, and by that she meant both the legal profession and the judiciary, more diverse, more inclusive. The purpose of this session in the afternoon, this 1 hour session, is not to just celebrate the installation of the statue and then forget about it until the next case comes up when we refer to the Constituent Assembly debates. I believe this is a beginning of a series of dialogues. And I believe that we will have a series of engagements based on the life of Dr. Ambedkar right through the year now, as we enter into the 75th year of the founding of the Indian Supreme Court. And I thought I'll just highlight a few questions. The Chief Justices are here, senior judges of the High Court are here. First, based on what we have gained as an insight into the life of Dr. Ambedkar, What steps do we take to make our legal profession an inclusive profession? Can all of us say with our hand on our heart that we are an inclusive profession? Or is our profession essentially based on networks? How are young lawyers admitted into chambers? Is there a level playing field for people who come from marginalized backgrounds who are extraordinarily talented, but just require a little bit of mentorship? Have we created a legal profession which is truly inclusive? Second, what are the significant obstacles which persons from marginalized backgrounds face when they enter the legal profession? Because these are duties which are cast on all of us, whether we are lawyers, as judges, to ensure that we confront these serious problems. Third, what steps should we adopt to provide diversity in the Indian judiciary? And fourth, what kind of mentorship has enabled those who have succeeded to succeed? We shouldn't just look at it from the negative perspective of what are the obstacles. Obviously, there are people who are succeeding and who have succeeded. Why have they succeeded? Who are the people who mentored them? What are the conditions in which they were able to overcome their conditions of discrimination or prejudice? So I do believe that what we will do now, after we conclude this particular session, is to have a series of engagements, not just on the Bahujan Samaj, but on the broader aspect of marginalization and its interface with the Indian judiciary. And how do we really ensure, what is it that we have to do? Somebody has to take those steps. I'm always asked, wherever I go now, and I've been engaging a lot in public consultations and public engagements. And I'm always asked, why are there not more women in the Indian judiciary? Why is it that you have only so many percent? And we'll see that in the next session as the figures come before you. Why is it that we have only so few women judges in the high courts? Why is it that we have so few women judges in the Supreme Court? There's something which I was in fact in conversation with the president last night. And I always explain to people that, well, in the Supreme Court, we draw upon a pool of available talent, where unlike, say, the American Supreme Court, where you can pick up almost anybody, you can make a senator a judge of the American Supreme Court. We can't make a senator merely because she's a senator a judge of the Supreme Court. You have to have a certain legal background. You have to have a certain degree of attainment in the legal profession. So we have to draw from the available pool. But how do we ensure that the available pool increases in the next 10 years or 15 years? Unless we take those steps now, as we will shortly see in the presentations, and I was actually here the whole day yesterday trying to look at the presentations, you will see that when it comes to the district judiciary, in several states in India, over 80% of the fresh recruits are women. 60% of the fresh recruits are women. 70% of the fresh recruits are women. That's an indicator to you of what is happening on the ground at the lowest levels. That is to say, if you're given an even platform, of opportunity to people and treat them as individuals who will be able to succeed without all the trappings which our legal profession gives them or disadvantages them with, they're entitled to and will demonstrably succeed. Now, how do we create those conditions in the legal profession, the mainstream of the legal profession? Is there no obligation on lawyers? We have the lawyers here today with us. And the president of the chairperson of the Bar Council of India is here. President SCBI is here. Secretary of SCBI is here. So many lawyers are part of this session. In fact, the Dalit lawyers in the Supreme Court came to me the other day and said that putting up this statue is an act of enormous support for our community, because it highlights the fact that we are not really behind the scenes, but we are a vital force in the decision-making process of the Indian judiciary. These are some of the things which I thought I would highlight. In the US Supreme Court, I wanted to focus on one particular aspect. Just this summer, the American Supreme Court dealt with a case called Committee for Admissions to Harvard. And they sought to challenge the use of race as one of the criteria in affirmative action programs. The American Supreme Court, speaking through Chief Justice John Roberts, held that the color of your skin or your race should have nothing to do with your right to seek admission. And they've outlawed completely the use of race as even a factor in admissions. They never had quotas, but they would use race as one factor in admission decisions. Even that has been outlawed in the United States. Look how far and how progressive our law has been. We regard equality not merely as equality in a formal sense, but we regard equality in a more substantive sense. And therefore, we believe, along really the legacy that Dr. Ambedkar has conferred upon us, that if you have to bring about true equality in society, you must factor in all those factors which lead to the loss of a level playing field. People from marginalized backgrounds do not have the kind of social capital. They do not have the kind of cultural capital. They do not have the kind of access to resources. Something as simple as access to coaching centers when you're appearing for the common law aptitude test. People from marginalized backgrounds are not as conversant with English, but our CLAT examination, which is a bedrock for entry into the legal profession, is entirely conducted in English. Now, by the very fact that the medium of the examination is in English, we are making our profession urban-centric, and it is wholly and completely biased against those who come from rural backgrounds, from marginalized backgrounds. What do we do as a profession to overcome this? I'll give you just one example of what the Supreme Court did recently. We have a clerkship program in the Supreme Court. It's an extremely vital tool for young members of the legal profession from all over the country for the purpose of their own advancement in life. What used to happen was that the clerkships typically, I know of a time in the Supreme Court when clerks were taken only from the National Law School. So if you didn't belong to a National Law School, you couldn't clerk with the judge of the Supreme Court, which I thought was extraordinarily discriminatory. In fact, part of our clerkship program was dealt with by Justice Rajiv Shakdar when he delivered judgment and said that what your people are doing is completely violative of Article 14. But we took the next step. Actually, I prepared a white paper last year, placed it before Chief Justice Ramana, and then eventually we have implemented it this year. And that committee also consisted of several of my very distinguished colleagues, headed by Justice Kaul. We have now completely reoriented our clerkship scheme so that clerks, we have an examination for recruiting of law clerks in the Supreme Court. This year, we held the examination in over 20 centers all across India. After we held the examination was held in two parts. There were multiple choice questions as first part of the examination. Then we gave them brief judgments, which were again mock judgments, to prepare a research note. Not more than a few hundred words. So it's something which they had to write in half an hour or 30 minutes. But the exam went on for the whole day. And the final aspect was a research note which you have to prepare for a judge. All this had to be done in the course of one day. We got some amazing people whom we have recruited. And we have allowed our judges then to interview those from the pool. We still give our judges a choice of selecting a few law clerks of their own, but the brunt of the law clerks come from this. The Supreme Court, in conjunction with the National Commission for Scheduled Tribes, has launched an internship program. The National Commission for Scheduled Tribes had approached me and said, why is it that our tribal students don't have access to the highest court? So we have engaged with the National Commission for Scheduled Tribes, and we are now engaging in a very modulated and a properly structured internship program. So I would really, the reason I thought I should talk more in practical terms as opposed to something very theoretically constructed around the life of this distinguished scholar, statesman, Constituent Assembly member, minister, and the architect of the Constitution and social reformer, is that I thought that we must all dwell today, since all the Chief Justices are here, senior judges of the High Courts are here, we must all reflect today on what we need to do to make the legal profession truly, truly more inclusive. Just a couple of things on a little bit of a few pieces of anecdotal evidence about the life of Dr. Ambedkar. My father used to tell me that as a young lawyer, there was a cafe in Kalavoda in Mumbai called the Wayside Inn. The Wayside Inn later on became very well known among lawyers for a variety of other things. But in those days, Wayside Inn was where there was one gentleman who would sit there every afternoon, writing furiously. He would have sheets of white paper and he would be furiously penning something. Later on, people realized that this was nothing then, nobody else than the chairperson of the drafting committee, Dr. Ambedkar, who would sit in the Wayside Inn every afternoon, writing out what he believed was the structure of the Indian Constitution. The Justice Gavai spoke about the Mahar Satyagraha case. A very interesting case, actually, which I thought I must refer to all of you and then conclude what I have to say for the concluding part of this session. And that was a case which Dr. Ambedkar lost, not a case which Dr. Ambedkar won. Mahar Satyagraha, he succeeded. But all of us know as lawyers that it is as much in the cases which you lose that you get the greatest satisfaction as opposed to the great cases which you have won. And this was a case where he defended Professor R.D. Karve's journal called Samaj Swasthya on charges of obscenity. And he was defending R.D. Karve. And Ambedkar mounted a spirited defense of the Gujarati journal, which dealt with questions of sexual hygiene and family planning, and proposed a legal test for obscenity, which was way ahead of its times. Ambedkar lost the case, but eventually he successfully got the magistrate to admit that the taboo around sexual matters should end. So look at the vision, look at the depth of his understanding of society. Another case which he represented was involved the defense of Philip Spratt, a British communist who was arrested on charges of sedition. There's a very interesting article on Dr. Ambedkar's life by Rohit Day, a historian at Yale, in his paper called Lawyering as Politics, the Legal Practice of Dr. Ambedkar. And he says that Dr. Ambedkar's ability to be at equal ease defending the civil liberties of communists, Congress workers, landlords, indigents on death row, within the limits of colonial law required a particular kind of deftness, making him one of the earliest precursors to Indian civil rights lawyers. Ultimately, Dr. Ambedkar was asked that what would he like to do if you were to talk in 1930 years after he began his law practice. And Dr. Ambedkar said something which has not been widely quoted. I'll quote that and I'll be ending my presentation this afternoon. And he said, legal practice and public service are the alternating currents in my life. He said they are the alternating currents in my life. I do not know on which current my life will end, whether AC or DC. So as we celebrate 100 years of his enrollment as a lawyer, there can be no doubt that in each role that Dr. Ambedkar played, be it legal practice or public service, he has left strong currents that continue to power our polity. Thank you very much.
Thank you, Honorable Chief Justice. It's always a pleasure hearing you. You've been so very instrumental in sensitizing us towards significant aspects of inclusivity, gender, and diversity. Thank you, Chief. Well, as we come to end of this session, I thank everyone present here. We will be starting with session 2 in few minutes. Thank you so very much. Good afternoon. Good afternoon. We'll be starting with session 2.
Saying, hey, Nicolo, you had 15 minutes of 15 has become 20, has become 25. That president was completely focused on. And he actually told me, he said, just ignore those people. And he told me at the end of it all, he said, everything that you are doing applies equally in my country. Everything. So why I say this to you is, I spoke to you about the impact we are making, the motivational impact. I spoke to you about generosity of heart. But you must also realize everything we are doing today is relevant to the world. It is relevant not just to the developing world, it is relevant even to the developed world. And it is, I give you an example of it. Just a few days ago, the Financial Times had an article. The Financial Times article pointed out, it said the number of cashless financial transactions in India last year were 90 billion. Okay? Oh, wait. Do you know how many cashless transactions there were in America? Would anybody even like to guess? 2.8 billion. Even China had 17.6 billion. So I want especially the young people to understand this. You are embracing change on a scale and intensity with a passion. Even you don't know the revolution you are creating around you. This is today the new India. This is the India which, if it carries on for the next 25 years, will be the Viksit Bharat that we are all aspiring to. So I must tell you, the reason the foreign minister has come is to draw encouragement, hope, sustenance from all of you, but also tell you that this 25 years is your era. It's your achievements, your talents, your motivation that will decide really where India is going. Now, I have spoken to you about the world, about, in a way, some of the achievements which has had an impact. But the truth is also, the world is a very tough place. The world is a very tough place. You can see that, you saw it during COVID. You can see it in terms of today, the impact of conflict. You can see it in terms of the security challenges. You can see it in terms of climate events. So, but what is necessary for all of us to understand is that the world matters to us. That era where the world was beyond our borders and we were safe inside our borders, that era is now over. Borders are actually, in terms of sovereignty, extremely important. But when we speak about globalization, everything that happens in the world outside will impact your life, and everything you are doing here, particularly if you're doing it on scale, in terms of a different level of achievement, that will also impact the world. And I say this to you because this is today the world in which we have assumed the G20 presidency. So why is our G20 presidency different? Because, there have been other countries who have done G20 for a variety of reasons. The first reason is actually the chair. The fact is, India has assumed the G20 presidency at a moment when India is mattering more and more to the world. It is mattering more to its world, partly because of our economic achievements, that from number 12 or number 10, we have now become the number 5 economy. It is mattering because today, whether it's technology, it could be digital, it could be our talent. I gave you Chandrayaan as an example, but you can see it in other ways as well. That we are today recognized as essential to the global workplace, to the global talent pool. It matters because we also today have demonstrated a capability. We have demonstrated a capability of helping other countries. I spoke to you about vaccine supplies, but you can see even today in, some country has an earthquake. Turkey had an earthquake earlier this year. We were among the first countries who were able to send a contingent out there to rescue people. But it's also because we look after our people. The respect that we get in the world because we look after our people. When we went into Ukraine under Operation Ganga to get our students out, or when we went to Sudan under Operation Kaveri to rescue people, 5,000 people who are working in Sudan. So in the eyes of the world today, it is our economic achievements, it's our technology capabilities, it's our talent pool, it is actually our capability, and it is a fact that all of this is done as a democracy. This combination puts India in a very special position, and therefore India's presidency of the G20 has expectations and responsibilities which are very exceptional. Now, one part of it is, as I say, it's about us and how we are perceived. But it's also the decisions we made about how we are going to conduct our presidency. Typically, a presidency is done in meetings. I have attended maybe more than 10 G20 meetings in my life. Mostly conference hall hota hai, log aate hain, airport se conference hall jate hain, meet, have a dinner, sign some piece of paper and you go. So if you look at the impact on the society or the input of the society, there is very little. This G20 presidency is completely different. We use the word Jan Bhagidari, and truly we mean it. This is the first G20 certainly I have seen in my long career, where the people of the country, where every region, multiple cities, different walks of life, from colleges to professional associations to the ordinary citizen, feels connected to that G20. And we are doing it because in Prime Minister Modi's view, in his vision, we want to use the G20 to prepare to make the world ready for India, that India which all of you are going to make. We also want India to be ready for the world. We want especially the younger generation, and we want the cities and towns and the states and union territories of India to actually understand fully the opportunities and the possibilities in the world out there. And in the last year, the difference we have been able to make is we have not done the G20 as an official program, we have done it as a national celebration. And that is actually a G20 with a difference. Now, what is the challenge in the G20? There are two big challenges. One is what is called the divide between the North and the South. The developed North is a term for developed countries. South is a term for developing countries. So, Viksit Desh and Vikashsheel Desh. So, their gap, their divide which has been growing. And secondly, the polarization that we see today between what you can call the East and the West, particularly as a result of the Ukraine conflict. So you have an East-West problem, you have a North-South problem. Guess who is in the middle? That's us. It is our responsibility today to find a way of bringing the world together, and we are confident of discharging this responsibility precisely because, as I said, we have today a respect in the world coming from our governance, coming from our economy, coming from our technology, coming from our independent foreign policy stance. So that sense today that this is a fair India, a generous India, a connected India, that these people will conduct their presidency responsibly, taking every view into account and find a landing ground which will be acceptable to everybody. That is today the task before the G20. Now, I had mentioned the world is a very difficult place, and it is a difficult place because, as I noted, we had a once-in-a-century pandemic, COVID, and COVID has had a terrible consequence across the world. You know, there are parts, in India at least, we have recovered in many ways. I must tell you, many parts, many countries have not been able to recover the manner in which we have. Secondly, the conflict, because again, it has shown today how much the world matters to us. That a conflict is taking place in Ukraine, an entire continent away. And that conflict is today creating problems in fuel cost, in availability and prices of food grains, in the access to and the price of fertilizers. It is actually creating inflation across the global economy. So the COVID, 3 years of COVID, a year of this conflict, already large parts of the world were struggling with debt issues, trade issues. And then we are seeing more and more climate events. And climate events